Supreme Court heard the oral argument in Helix Energy Solutions v. Hewitt on Wednesday. The case is on employment law and overtime pay. Michael Hewitt, who made over $200,000 a year on a day rate, believes he's owed overtime by his previous employer, Helix Energy Solutions, as he worked 84 hours a week. During the argument, Supreme Court Justice Clarence Thomas asked Hewitt's attorney, Edwin Sullivan, point blank if he thought his client's, quote, compensation was a sham. Sullivan argued that, quote, it would be only a sham if they called it a salary, which it is not a salary. Thomas responded that, quote, you certainly don't normally think of someone making $200,000 a year as a day laborer.
Do you think this is your client's salary is a sham salary?
I don't believe my client received a salary at all. He was paid on a day rate. If they call that a salary, then it is a sham because—
Do you think his compensation was a sham?
I think it would be only a sham if they called it a salary, which it is not a salary. And
The difficulty is just for the average person looking at it, when someone makes over $200,000 a year, they normally think of that as an indication that it's a salary. And you certainly don't normally think of someone making $200,000 a year as a day laborer. And so you've got this ill fit. If you were talking about $20,000 a year, people would say that makes sense. And I think that's the difficulty that you're having. And a point that Mr. Clement made, I mean, the regs say that's their own Department of Labor's regs say that's an indication that you are highly compensated executive. So I don't know. I think your difficulty is just the visual. And for you to say that's not a salary to the average person is a difficult
Your Honor,
challenge.
Your Honor, I take your question obviously in great faith. 601C, which they're referencing, does say that, look, high pay is a strong indication even of exempt status. And I don't disagree that that's the regulation. But to be in the capacity of a bona fide executive, which is what the statute requires, but
it doesn't define, statute doesn't really define it. That's the difficulty.
Sure, but it allowed, obviously, the department to do so, and the department looked and they talked to industry. And in fact, back in 1940, if you look at the Stein report, who's the hearing officer, page 19, he said it was almost universally recognized by industry, including 3 oil companies on note 6 of that report, that salary was universally recognized as the hallmark of exempt status. There's a reason that it's not just a concession on duties. Yes, I conceded that Mr. Hewitt that Helix could otherwise satisfy the duties test. But there are 3 tests that the Secretary implements, all to be for their statutory directive of who is a bona fide executive. And the most important of those tests is the salary basis test. They did not pay him that.